Imagine being denied your rightful share in something that has been passed down through generations. For years, daughters in India have fought for their rights to inherit ancestral property. But did you know the law wasn't always on their side? In this video, we are breaking down everything you need to know about daughters' rights to ancestral property in India, especially after the landmark changes in the law. Stay tuned because you might just find out how the law is evolving in your favor. Before we dive in, let's break down the key points we'll discuss today. First, what is ancestral property? 2. How the law has changed over time for daughters. 3. Key Supreme Court judgments on daughters' rights. 4. What to do if your rights are violated. 5. Recent updates and court decisions. Let's begin by understanding the concept of ancestral property. Ancestral property is property that has been inherited up to 4 generations of male lineage. The law was traditionally very male-centric, but they started changing over time. Under the Hindu law, this property was earlier restricted to sons, but reforms have broadened the scope to include daughters as well. This right isn't just limited to property left behind by a father. It also includes any property left behind by the grandfather or great-grandfather. Now, this is where things get really interesting. Historically, daughters were not allowed to inherit ancestral property. This all began to shift with the Hindu Succession Act of 1956, which attempted to standardize inheritance laws for Hindus. But even then, daughters were treated as second class when compared to sons. The real game changer came in 2005 when the act was amended to give daughters equal rights in ancestral property. Before this amendment, a daughter was not considered a co-partner, meaning a term that refers to a person with an equal right in the ancestral property. After 2005, daughters were recognized as equal co-partners, putting them on the same footing as sons. Several landmark judgments have further clarified and reinforced this change in the law. First is Vineet Sharma versus Rakesh Sharma. This is one of the most important cases regarding daughters' rights. The Supreme Court ruled that daughters have equal rights to ancestral property regardless of whether their father was alive on or before the 2005 amendment. This was a big clarification because previously many courts held that the father had to be alive in 2005 for the daughter to claim her share. 2. Prakash versus Pulavati. This case initially restricted daughters' rights, stating that the father must be alive for the 2005 amendment to apply. But the Vinita Sharma judgment overruled this. 3. Dhanamma alias Suman Surpur versus Amar. In this case, the court ruled in favor of the daughters, affirming their rights in ancestral property, even if their father had died before the amendment. These judgments solidified the equal treatment of daughters in the context of ancestral property. A key takeaway from these cases is that the law now treats sons and daughters equally, whether or not the father was alive at the time of the amendment. If you find your rights to ancestral property are being violated, here's what you can do. First, consult a legal expert. Always seek professional advice, especially if you're unsure of your legal standing. 2. File a partition suit. If you are being denied your share, you can file a suit for partition. A partition suit will legally divide the ancestral property among the rightful heirs. 3. Mediation. If court cases seem daunting, you can also explore mediation to settle disputes. Remember, it's important to act quickly. Delays in asserting your right could complicate things further, especially if other family members are trying to sell or transfer the property. In a notable recent decision, the Karnataka High Court affirmed that even if your daughter passed away before the 2005 amendment to the Hindu Succession Act, her legal heirs can claim her rightful share in the ancestral property. This ruling is a continuation of the Supreme Court's interpretation that a daughter's right is by birth and it does not cease with her death, ensuring her children can step into her legal position to claim her share. For example, the Supreme Court judgment in Vinita Sharma versus Rakesh Sharma reaffirmed that daughters have equal co-partnership rights regardless of whether their father was alive at the time of the 2005 amendment. This interpretation by various high courts has extended these rights to ensure that daughters' legal heirs can claim the share, further solidifying gender equality in inheritance law. This evolving legal landscape emphasizes the progressive direction the courts are taking in protecting the property rights of daughters, ensuring fairness and preventing exclusion based on outdated norms. To sum it up, here's what we have learned today. First, ancestral property refers to property passed down through male lineage, but daughters are now have equal rights. 2. The 2005 amendment to the Hindu Succession Act gave daughters equal rights, making them co-partners. 3. Key judgments like Vinita Sharma solidified that daughters have rights regardless of when their father passed away. 4. If you feel your rights are violated, legal remedies like partition suits are available. 5. Recent updates continue to expand and protect these rights for daughters. If you or someone you know is facing challenges in claiming their share of ancestral property, don't wait. Seek legal advice, stay informed about your rights, and remember the law is on your side. Make sure to subscribe to this channel for more important updates on legal rights and share this video with those who need to know. Let's make legal knowledge accessible to everyone. Take care and bye.